I can see you, Mr. Denton. Can you hear me?
Yes, sir. Welcome back, Mr. Doss. This is case 95 DR 6110, State of Florida Department of Revenue, Monica Smallwood and Sugret Doss. Mr. Doss, if you raise your right hand, my question, as always, is do you swear or affirm to tell the truth?
Always.
Okay. Ms. McCarthy is the attorney for the department today. Ms. Britt's our department representative. We have Ms. Taisha Scott. I presume Mr. Doss secured her presence as a court order for this afternoon's hearing. We're here on an emergency motion to reinstate driver's license because the underlying order is void for lack of subject matter jurisdiction with memorandum of law and incorporated declaration of fact. I see there's Mr. Doss filed some supplemental authority with exhibits, 150 some odd pages on March 28th, 2024. There was previous proceeding February 26th and a couple of orders that followed on March 21 regarding driver's license and prior motion for relief from judgment, which were denied. And one of them was denied, the other was granted, requiring a lump sum payment. That's still, I think there's some time left to mid-April. So that's my review of the record. Mr. Doss, anything else I should be aware of on your motion, or would you like to make a presentation?
Well, before I get into that, could I ask, who's Mr. Gilbert? Matthew Gilbert? I see the Office of Attorney General. Is he an attorney sent here specially, or is he just somebody overseeing? What's his actual official capacity? I've never seen that name.
He's training and shadowing.
He's training and shadowing, so he is an attorney for the Office of the Attorney General, correct?
Yes.
Okay.
So he's here at the last hearing, sir.
And Mr. McCarthy, I guess you're going to conduct this hearing as well?
I'm the attorney for the Department of Revenue.
Okay, so, and Ms. Britt, has Mrs. Britt gotten over her laryngitis from last week?
Ms. Britt was previously placed under oath, and I've heard no problem with her voice today.
Okay, just want to make sure. I appreciate that. So, again, now I did read for some, and I want to make sure the record is unobscured. Just for some record keeping, I did read your recommendation, and I wanted to state for the record that the cases that you cited were cases that related to people who were previously married. And Ms. Smallwood and I, as you are aware, we're not married, correct?
Okay.
You are aware that we were not married?
These are your facts, sir, and that seems to be the
okay,
case.
We'll stipulate that Mrs. Smallwood and I were not married. Now, furthermore, the cases that you cited, which don't apply to this case, also had underlying orders that came from another jurisdiction. So I wanted to make sure that's clear on the record, and if there's no objection, I'll move forward.
Your motion preceded my order, so are you seeking rehearing and reconsideration, or what are you seeking?
Well, you don't give an order, you made a recommendation, but I understand Judge Smith rubber stamped the order. Your recommendation, I mean, Judge Smith rubber stamped it without reviewing the facts. And one of the glaring issues that I found with Judge Smith, one of his orders was he claimed that it appeared to be res judicata. And I know I don't have to give anybody a first year law class because I'm not a law student, by the way. That res judicata would mean that the merits had been litigated. So Ms. McCarthy in our last hearing stated that the issue is res judicata. Could Ms. McCarthy, for the sake of clarity, tell me when were the merits of the underlying order ever litigated?
Again, are we speaking about your present motion or the previous motion? I don't have the power to vacate or reconsider if that's not the request in your present motion.
Well, you're also beyond, because the license was, I believe, suspended improperly, and the order that suspended it is a void order. So we seem to be going on this circular dance when the facts are pretty clear. And I'll recitate the facts that what I now see, because since I went and did a public records request and a request for production of documents, the state of Florida opened up Ms. Smallwood's file so I could see everything. And what's interesting is the case began, I guess, in North Carolina back in 1993. And it was subsequently, I guess, moved to Leon County, Florida in 1994. What did not happen between 93 and 94 was a service of process. And the rule, as we know, which has been in effect for some time, was that the original complaint, the initial complaint, was not served within 120 days, the summons and complaint within 120 days, The court had a couple of options, one of which at the time would have been that they've had to dismiss the case. They didn't do that. So I guess I don't know if it went back to North Carolina or not, but somehow it appeared in Hillsborough County. And I believe the date is May 15th is when this case began in Hillsborough County. In fact, May 15th, 1995. And we can look at the docket. You have a copy of the docket as well, correct?
I'm reviewing the docket. I think the recitation of facts in the 3/21/24 order are, they're easy enough to follow. I don't know that there's anything that was misstated there unless you have a point of clarification.
Well, a point of clarification is I guess we could stipulate that the record also shows that in between May 15th, 1995 and June 1st, 1999, when is an alleged service of process, there was no record activity of a extension of time to serve by the court, or even a showing of good cause by, I believe at the time would be Manish and McIntosh, who were the representatives for the state of Florida. Can we stipulate to those sets of facts as well?
Are you asking me? Because I'm not stipulating anything, sir. I will take judicial notice of the record.
Take judicial notice of the record. Good, there we go. Mandatory judicial notice of the record, in fact, pursuant to Chapter 90 of the Florida statutes. And the record shows that it was initiated in 1995. It wasn't served until 1999, which would be beyond the 120 days for service of process. The law demanded, and I'll go to Gaines versus Placilla, and we can go to 634 SO2D 711, where it says that an action be dismissed without prejudice where service is not made upon a defendant within 120 days after the initial pleading, where there is no showing of good cause for the delay. And as we look at the clerk's record, we see that that did not happen. So I'll just say that the court erred in not dismissing the case at that point. We go further. Because it doesn't show that there was a good cause for failure to serve the defendant within 120 days, Rule 1.070, which mirrors 12.070, states that the trial court should have dismissed the case. And we go to that Patterson versus Lowenstein, you have that as well. And I think that most of these are pretty clear. And back to the issue of res judicata, I want to cite the Florida Department of Transportation versus Giuliano, and that's 801 SO2D 101/105, that the issue had to be litigated and determined. And to date, there's been no definitive ruling as to whether or not the court's position is that it had subject matter jurisdiction, and definitely didn't have personal jurisdiction for the case. So again, I'm challenging jurisdiction, and I don't know if you have the capacity to even rule on this matter. But let's continue to move forward. It's well settled that a trial court may not exercise its discretion to refuse to dismiss a case under Rule 1.070I unless there is record evidence of efforts made at service during the 120-day service period, which would support a finding of good cause under the rule. And even if you may have made an attempt, you had the duty as attorneys to ask the court for an extension of time to serve their initial complaint and process. That, of course, in the record is not evident. Moreover, when this action began in 1998, the Hodges versus Knoll holding would have been the binding case law, and you can go to 675 SO2D 248, 249, that's 1996. Now, as to the language for the time limit for service of process is pretty unambiguous, and because it requires that an action shall be dismissed without prejudice, absent a showing of good cause why service was not made within 120 days, the discretion afforded the trial court is limited to those cases in which a reasonable cause for failure to effect timely service is documented. I tell you again to take mandatory judicial notice, of the clerk's docket for case 1995 DR 6110 that's filed within the Hillsborough County court. There's no evidence showing of good cause, and there definitely was no extension of time to serve process. Now, let's move furthermore. When there's an issue involving a defective service, and as we go to, and I want to make sure I get the proper date in the court's record, after the service allegedly was made in 1999, there was no activity, and the clerk issued a default judgment. The clerk's default judgment would be rendered void because it was an improper service of process. And I'll give you the exact date. I'm working with a couple of different things right now, but we see on 6/1 is when you allegedly served. On 7/19/1999, if you look at the clerk's docket, it said a motion for default and default entered. Well, there's no response, but the default would be rendered void because of the defective service. And unless somebody's going to offer anything counter to what the rule what the law and well-established case law would require that you have to do, I would just have you just note that for the record. So since there's no objection, we'll move forward. Furthermore, in looking at the final judgment, which you do have a copy of that one as well, I did submit that. And oddly enough, my portal was acting a little quirky on Thursday and Friday, so I couldn't submit it electronically, but I'm glad that the clerk did make it available for you. And also, I see that I made a filing on the 31st that didn't appear in the record today. Maybe it's just a matter of the court or the clerk updating the record. But if you go to your binder with the supplemental authority,
I don't have any binders, sir, but I have what's filed as docket entry 179, 125. I said 150, but it's 125 pages that were filed on March 28th. I'm not aware of anything filed March 31st. It may be too fresh and not imaged yet by the clerk for me to see.
Okay, very well. Go to Exhibit E, which is the final judgment, which is stamped March 1st, 2024, from the clerk. And when you get there, it'll probably be a little bit easier for you to pull it up than, I don't know. I think I gave it to Miss Scott as well. And Miss Britt should have it if it should be imputed to Miss Britt.
Right. I'm looking at the final judgment after a hearing held 10/3/02. It's got a rendition, a docket stamp date of October 17th, 2002. Yes, sir. What do you want me to be aware of here?
Okay, that final judgment does not have a child support guideline worksheet attached. And it is error for the trial court to decide the issue of child support without the benefit of a child support guidelines worksheet. And that's actually Florida Family Law Rules of Procedure 12.285, and that was J. And I subsequently attached the Durham versus DOR, which you can cite it at 850 SO2D 653, and that actually came out of the second DCA back in 2003.
Did you actually complain about that in your motion, the emergency motion?
I don't think I have to, but you're aware of it now. And actually, you would have had a duty, not necessarily you, but the attorney who pushed the case had a duty to inspect the docket before she proceeded. Now, whether it's just a simple issue of a 1983 issue, or if it's an abusive process, nevertheless, the rule is clear, and I'm pretty sure that Ms. McCarthy as well.
When did that rule go into effect?
Doesn't matter when it went into effect. It was in effect in 2003.
Okay.
And unless you have some rule that would supersede what would have happened, but necessarily in 2003, then we're still where we are. And it still doesn't undo the fact that after the 120 days you didn't serve process. And that's been in effect since that's one of the bedrocks of American jurisprudence is jurisdiction.
Okay.
And then looking at the record, by the way, the case came out of North Carolina. Ms. McCarthy made a comment that Florida court had always had jurisdiction, and that's inside the transcript. Now, what I want Ms. McCarthy, because she made herself a witness, she testified to that when she said it. When did Monica Smallwood file a application for services in the state of Florida? Because I haven't been able to find that, and my request for production hasn't seemed to have produced that.
Are you calling the attorney as a witness?
The attorney made the statement. I just need anybody. Miss Britt can do it. She's the representative for the Department of Revenue.
I don't think that's something to be testified to. It's in the court record.
Can you please provide it? Since you said it's in the court records, I appreciate that. Can you
Read the
please?
petition. It's under the Florida Statute 88. That's how jurisdiction is obtained. We went over this the last time.
No, we did not go over that. Is it your position that Miss Smallwood filed that complaint in Florida?
It's
Okay, so
It was filed through the child support agency, sir. Once
In
again,
Florida.
Florida Statutes 88.
I need the evidence of that petition, because what I do see inside the record is a summons, and what's not attached to that summons is a petition, not the original summons. I find that to be pretty interesting, and I'm aware that Minish and McIntosh was notorious for some unethical behavior, but I'm demanding, not even asking, I'm demanding, because you made the statement now on the record, to show me the original petition filed in the state of Florida on behalf of Ms. Smallwood. Because I'm familiar with Rule 12.040 C2, where the representative for the department only represents the department and not the recipient of the services. So I need to see, because she's now made it, and I can give you time if you want to continue this, for Miss McCarthy to produce that petition, the original complaint and petition that was filed back in 1995, because it's not in the record. And I know Miss McCarthy would not do anything that would violate the rules of professional conduct.
What do you want from me, sir? You want a continuance?
No, I don't need a continuance. I need Miss McCarthy to produce the document that she claimed existed in front of me and the whole world.
The department has no obligation to produce a document that's
Then you have no evidence to rely on. Competent substantial evidence will require that you produce it. And if you open your mouth and make an utterance to its existence, I'll calibrate. Oh, you will produce it. So she needs to produce it. It's not in the record.
Okay, go on with your argument, sir, and your facts and your evidence.
Okay, well, it's a fact that it's a fact. I understand that, Mr. Den. Please, let's not try to obstruct my record. It's a fact that the initial complaint was not served within 120 days. It is a fact that the record is void of a initial petition or complaint filed by Monica Smallwood on behalf of Monica Smallwood. Also, the record shows that the state of North Carolina allegedly, some kind of way before you all changed it, filed a petition, filed the amended ERISA petition. It still wasn't served within the 120 days, and it never went back. And interestingly, at the time, Chapter 88, also before they changed the rule, did not allow jurisdiction to be garnered by virtue of the petition by itself. Back in 1997. So just for your edification. Now, I want you to take mandatory judicial notice again of this case, the Con versus Con case, as reversible error to fail to include the child support guidelines worksheet in the final judgment establishing paternity and child support, and that's the Department of Revenue Ex Relation RSM versus BJM, and that's 127 SO3D 859, 861. It came out of the second DCS 2013, so it still would be reversible at this point. And by the way, because the filing of a child support guidelines worksheet is mandatory, reversal is required even if the omission is due to the party's failure to comply with the rule. And the 12.285 has been in existence since, I guess, the Supreme Court started it back in whenever, 75, which is as far back as I could go, is like 90, whatever it was. But anyway, go to the Durham case and go to 850 SO2D at 654. And by the way, Mr. Denton, since you did look at the child support final order, I believe it's like 4 pages, correct? Final judgment.
Yeah, I'm familiar with the order.
Okay, 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 I'm glad you said that. By the way, on the face of the docket, it's evident that service of process didn't happen within 120 days. And an error which appears on the face of the final judgment, of course, is naturally reviewable. But what would make it also necessary is it's reversible and it's actually void. So for 20 some odd years, the Department of Revenue, knowingly and through various attorneys, to include Ms. McCarthy, has maliciously pursued this action without simply looking at the record. And for the record also, I've been arrested some 12 or 13 times on a void order, which is pretty frustrating, to say the least. And despite you all knowing it, and that not just you, Mr. Denton, it's previous hearing officers, Judge Sabella, Judge Ficarota, Judge Ayers, Judge Smith, and I know you all are not this incompetent. I believe you're motivated by something a lot more sinister, but you're not this incompetent. And in the face of these facts, the Department of Revenue, whether it's Ashley Moody, Pam Bondi, even Charlie Crisp, for years have pushed this action. And you've been aware that you had no subject matter jurisdiction. This is going back to when I first had an understanding of what subject matter jurisdiction was. And yet you still refuse to do what the law required. And by the way, there's no parenting plan for Miss Smallwood and I either, which would mean that there was no competent substantial evidence by which the department could have based whatever the amount they gave was, because we had no idea what was going. And we know that the Department of Revenue, through an administrative proceeding, can't make a determination on time sharing or custody. But that's not even an issue for us to address today. The only thing we have to address today is that the 120-day period for service of process did not affect service within 120 days. That there was a default judgment entered in 1999, and we know that the rule requires that a default judgment entered on an improper service is void. And as we continue to go on, so I want to make sure the record is clear, the statutes governing service of process are strictly construed. And that's the Stella versus, I won't butcher the name, but you can go to 76 SO3D 1054,155. Furthermore, I wanted to bring this to your attention as well. If you look in the court's record, you'll see that there was more than one amended complaint. The rule only allows you one amended complaint for cause. After that, you must get permission for the court for leave to amend. And unless there's an objection to what we see, there was more than one amended complaint in this case. And I'll just give you the rule. It's the Florida Rules of Procedure 1.190 states that a party may amend a pleading once as a matter of course at any time before a response to the pleading is served. Otherwise, a party may amend a pleading only by leave of the court or by consent to the party. We know I didn't consent to anything, and that's within the rule. And by the way, in Warner, Warner-Lambert Company versus Patrick, 428 SO2D 718, the Florida DCA, the fourth, in fact, ruled that they reverse and remand the case to the trial court with instructions to dismiss the amended complaint and vacate the default final judgment. And that's actually inside of your inside of the exhibits that I gave you as well. And now, in saying that, as I put inside of the record as well, it's not to say that at some point in time the department could not have amended the complaint, but now because they're not a child anymore, the 36-year-old individual is now beyond the 4-year statute of limitations for when the department could have even brought back the case. We have a dead case. And at any time the department, through their various attorneys, had every ability and option to have corrected the record. But what they chose to do was disregard well-established law. And because I don't have the original complaint, the court has no basis to show that the proper grounds for establishing jurisdiction are even in the record. You know, before the court can take jurisdiction, it has to say, okay, we have jurisdiction. Did the facts giving rise to the action take place in Florida? I need Mrs. Britt or Mrs. McCarthy. They can answer it, but I don't have any proof in the record that there was an allegation that the facts or events that gave rise to this action took place in North Carolina, Florida, or Texas, or anywhere else. There's absolutely no evidence in the record whatsoever to have supported this. And I know I'm not the only person who suffered because of the egregiousness of the Department of Revenue. And as I told you before, I think it's motivated by, more than anything else, the hue of people's skin. And of course, if you're poor, you're just the same as being black in this state for sure. But these disregardings of the law, despite what you may do, whatever you do today is not going to change anything. My position is clear and the law is clear. I'm just a little perplexed as to why not only many attorneys for the Department of Revenue have chosen not to do the right thing, but the chief judge who hires hearing officers and even the attorney general's office who hires attorneys has done nothing at all to correct this problem. I know it's pervasive. Nonetheless, there's no grounds play it anywhere that show that Florida court had grounds for jurisdiction. Now, failure to adequately allege the relevant jurisdictional basis does void any attempted service, even under long-arm statute. So, Ms. McCarthy did make a statement in open court, in this hearing, it's not court, in this hearing, that this petition or this complaint exists. I'd like to see the complaint. In 1995, well-established law required the service of process of an initial complaint and summons within 120 days of filing. The 120-day limit to effect service of process, which was established by the Federal Rule of Civil Procedure 4J, we know that's called federalism, is to be strictly applied. Now, and if service of the summons and the complaint is not made in time, and the plaintiff fails to demonstrate good cause for the delay, the court must dismiss the action as to the unserved defendant, which would have been me. And that's Morales versus Ferry Rand, and that's 578 SO.2D 1143, 1145. And we don't have to continue to beat this dead horse, but I'm going to. It doesn't show successful service of process within the first 120 days of the DOR or Minister McIntosh filing his complaint summons. And by the way, the docket doesn't show any effort whatsoever of good cause for not serving it within the 120 days. In 1995, when this case was initiated, the law mandated that the court dismiss the action if it wasn't served within the 120 days, and there's no showing of good cause. Go to Hodges versus Knoll, that's 675 SO2D 248, and it says a trial court may not exercise its discretion to refuse to dismiss a case under rule that's 1.070I unless the record evidence of efforts made at the service during the 120-day period, which would support a finding of good cause under the rule, that still would not excuse you showing the court good cause. It doesn't, and by the way, it shows that the DOR did amend its complaint twice without leave of court, once on February 9th, 1998, and again on September 10th, 1998. The rule for amending a complaint under the rule I've already mentioned earlier, which is Civil Procedure 1.190A, only allows one amendment without leave of court. You can see Fusiller versus Markov, that's 676 SO2D 1053 and 1054. And as I stated before, a party may amend the pleading once as a matter of course at any time before response to pleading is served. Otherwise, a party may amend the pleading only by leave of the court or by consent of the parties. You already gone to that. Well-established law required the court to dismiss the second amended complaint and vacate the default judgment entered by this court on July 19, 1999. This court held an amendment without leave of court. This court held that an amendment without leave of court or consent is generally a nullity, and that's Troso versus Florida, I guess it's Insurance Guarantee Association, but anyway, it's 538 SO 2D 103, 105, and that was the Florida Force DCA. And by the way, the law requires that DOR attorneys, child support hearing officers, and the judges of 13, despite what they may think, to follow all statutory provisions and well-established laws regarding service of process. And that's, I don't want to butcher the name, it's Shelkis versus Sutton Hill Associates. And that spelling is SCHUPAK versus Sutton Hill Associates. And that's 710 SO2D 707, 708. And it's clear, strict compliance with statutory provisions governing service of process is required in order to obtain jurisdiction over a party. It's clear that didn't happen. Well-established law determined that an order entered without subject matter jurisdiction is void. You definitely didn't have subject matter jurisdiction because you never pled. Or at least in the record, there's no evidence that jurisdiction was ever pled, despite what Ms. McCarthy just said. But I'm going to hold her to that. And you can go to Cole versus State, that's 714 SO2D 479, 489-490. That's out of the second DCA in 1998, by the way. And the Florida DCA did hold that an order entered without subject matter jurisdiction, the second DCA did, is void. Now, we can go back to Rule 12.540 as well as 1.5404B, B4. That states.
Well, I was about to ask you, is that the rule that you're citing as the basis for this emergency motion that you filed?
It's the basis for everything, that the underlying order is void. And I can challenge jurisdiction at any time. And the fact that everyone has put in such an effort to disregard the question of jurisdiction, we want to say it's res judicata. And the second DCA never addressed subject matter jurisdiction.
Sir, I made a finding on the merits in that previous order, and then also made a comment about res judicata. But go on.
Yeah, and you're wrong. It wasn't if it was litigated, show me exactly where it was litigated. That's not difficult, and you're supposed to be a hearing officer. You've injected yourself in quite a few of these hearings. If you have a witness, Mr. Denton, which I didn't know you were the attorney, have the witness come forward and produce the document so that I can cross-examine the witness as to the veracity of the document. There's
a previous finding by Judge Ayers regarding res judicata. There's a previous finding on your.
No, she did not. Judge Ayers cited the case that did not apply to this case. She never addressed the 120-day service of process, and if she did, show it to me.
And Judge DePaul made a comment that res judicata appears to apply on the.
Appears. Tell him to prove it. That's Judge Smith. Tell him to prove it.
It's a she. Judge DePaul handled the emergency hearing, or
she may have she recited what Miss McCarthy said. I don't even know if they're listening or not. Whether she said it appears.
Next parte order that determined your motion was not an emergency.
No, that's fine. But the bottom line still exists. There's no evidence that you served within 120 days. Just have one of the judges say that the 120-day rule for service of process does not apply to Mr. Doss or people who are similarly situated to Mr. Doss. That question has never been addressed. Tell the judge before they rubber stamp it, because we know that Gregory versus Rice stated that a judge should take he can take your recommendation, but he's not merely to rubber stamp it. He's supposed to go and check the record. So it should be really easy for them to just write the doggone order out. And then I can either mandamus or whatever we have to do. Because now that becomes a fundamental law, an issue of fundamental rights protection. But the 120-day, I need a judge somewhere to say the 120-day rule was strictly complied with. That's the issue.
Okay. Anything else, sir?
Well, I've challenged jurisdiction. I just need you all to put it in the record. And by the way, is Mrs. Britt, what's Mrs. Britt here to testify to?
She's here because she's a department representative. Nobody's called her as a witness yet.
Okay, let me go ahead and cite Venetian Salmi Company versus PARTHENAIS 554 SO 2D 499, 502 out of the Florida Supreme Court. If a defendant wishing to contest the allegation of the complaint concerning jurisdiction or to raise a contention of minimum contacts must file affidavits in support of his position. I've done that. The burden is then placed upon the plaintiff, which would be the Department of Revenue, to prove by affidavit the basis upon which jurisdiction may be obtained. Can I call Ms. Britt as a witness, by the way?
What purpose?
To verify that it's the department's position that all the necessary prerequisites for bringing the action were met.
What?
Yes or no, Mr. Denton? And if no, just tell me
Are you
why.
calling her? Are you
Yes.
asking permission to call her?
I want to ask Ms. Britt. I want to call Ms. Britt as a witness.
All right. Well, Miss Britt, you've already been placed under oath. I'll do it again just so that it's clear on this record. If you raise your right hand, do you swear or affirm the testimony that you're about to provide will be the truth?
I do. Stanford Britt, Department of Revenue Specialist Local 2.
Okay. Whatever your questions are, Mr. Dobbs, go for it.
Ms. Britt, can you assert or testify on behalf of the Department of Revenue that the Department of Revenue served the initial complaint within 120 days of its filing? The complaint and the summons within 120 days of its filing?
Your Honor, the department objects to that question. It's calls for a legal conclusion,
No,
not an issue of fact.
Sustain that question.
wait a minute.
Already taken judicial notice of the record, sir.
No,
And
wait a minute. Hold on. What we're not going to do, especially you two attorneys, is play this game. It is an issue of fact. Okay, hold on. Strike that first, and then I'll come back to it. Ms. Britt, do you have a copy of the docket in front of you for case number 1995-DR6110? Do you have a copy of the docket?
No, sir.
Can you all provide Ms. Britt a copy of the docket, either through however you all may serve her or give it to her, so we can get to the bottom of this?
Once again, the department would object. Ms. Britt is not a critical witness to testify to anything that appears on a docket.
Yes, she can. Yes, she can. She's
taken judicial notice of already, so it's already within the record. It's irrelevant.
What's the legal basis for that? What's the legal basis for that? What's the legal basis for her statement?
Mr. Doss, are you asking Ms. Britt to tell me what the record says?
Or
are you asking her for her legal opinion?
I didn't ask her for legal opinion. I didn't play. Let me play the word game, Mr. Den. My question was clear. I'm not speaking one of my foreign languages. I asked Ms. Britt, does she have a copy of the docket?
She said
there's an official copy of the docket in the exhibits. Give Ms. Britt the exhibits. In the official docket, the case summary is in the exhibits. And she can look from there. It's stamped with the clerk's stamp. And by the way, whenever there's an issue of fact, there is a basis for me knowing. It's an issue of fact. The 120-day question is an issue of fact. You having to dismiss it is an issue of law. So now, can you please, through whatever means you all have for transferring information,
you carry the burden here, so why don't you display the record on your screen? Share the screen to your heart's content. If you'd like me to facilitate, I can try.
Oh, you don't have, okay, so let's go to page 84 of the docket would be exhibit, roll it back up, which is why I gave it to you all.
So
exhibit D, go to exhibit D. Go to exhibit D.
Are you not capable of sharing this on your screen?
I think we can, but it's a pretty large binder, so let's try it this way. I don't know if it will. So you see the respondent's supplemental authority, correct?
Yes, correct. We can all see that on the screen, I believe.
Is there a way for me to share this with her, or you can share her this with this PDF via email or whatever source that you all tend to use for sharing this?
We're all looking at the screen. Whatever you put on the
Okay,
screen,
that's fine.
you can ask her a question about it.
Ms. Britt, while I scan this and the screen goes through its phasing, are you familiar with the case summary for case 1995 DR 6110? I don't hear.
I'm only familiar with the recent things that I can see on my side in my department as I am department reporting.
Okay. Can you see page 70 of the 120 pages submitted that comes from Division YD, which is I guess titled Case Summary Case NO.95-DR-006110 Smallwood versus Doss?
If that's what you're showing on the screen, sir, then yes.
Do you have any reason to believe that it's not authentic?
I don't know what you want me
Do
to.
you believe it's a clear record of the clerk's docket for this case?
As far as I can tell, but again, this isn't my department.
The department would object. She's not the proper person to authenticate whatever these documents are.
I mean, I think it just seems redundant because I've already taken notice of the record. Mr. Doss, your recitation of the facts, I don't think that there's anything incorrect in what you're saying in terms of the delay in service. This is all something that I wrote about in the previous order. Yes, there were delays. There's a 120-day rule that requires service. Didn't happen on the second petition. Didn't happen on third petition. I mean,
and it's your position that the 120-day rule does not apply to me?
No, it applied then, but you're bringing it up 2 decades later.
Is it your position, Mr. Denton, that subject matter jurisdiction cannot be challenged at any time?
No, my position is the link that you're failing to connect for me is why this is something that you're able to challenge under 12540.
It's a void order.
Okay.
And unless you have some case law, and not whatever you cited didn't make any sense, which I was kind of disappointed. I actually thought you were a little bit more competent than that. The case law that you cited does not have anything to do with the issue of subject matter jurisdiction in the 120-day rule.
Subject matter jurisdiction, I don't think was raised in the previous motion.
Of course it was. Of course it was. Of course it was. We're not going to do that. It was challenged back in 2013.
Again, are we reconsidering the prior order and the prior motion? Is it a new motion? Are we focusing on the driver's license?
No, what I want to focus on is the underlying order. Because from that, everything else stems. If the underlying order is no good, nothing you've done is any good. So, but anyway.
Did you have any other questions?
I have plenty of them. I wish you would quit interrupting me.
Your Honor, it's 5 o'clock. It's
hey, you said it for 4 o'clock. I don't know if you have to go eat or whatever you have to go do, but the bottom line is this.
I have to go visit my friend whose child is in the hospital with me, so I do have to leave.
Well, then I want you to do your job.
We're not much past 5, Mr. Doss. So if you can
listen, wait a minute. What you can never do is use time as a basis for denying me due process. I know that for a fact.
If you can't complete your argument and
the argument, I
hear the same thing over and over in terms of what you're saying to me.
Mr. Denton, I wish, you're a hearing officer, but for some reason you always find yourself in the middle of these hearings. Your job is to hear and rule on the facts.
And I've been listening for 45 minutes.
Hear. Didn't say speak. Rule on the facts.
Move on.
Objection.
Move on.
I object to Mr. Denton interrupting my presentation. Mrs. Britt, do you see that stamp that's dated March, first day of March in 2024? Do you see that stamp?
Ms. Britt, you're muted.
Yes, sir.
Okay, do you have any reason to believe that the stamp is not authenticated by Adam Dungan, who is a deputy clerk?
No, sir.
Okay, thank you. Now, as we scroll up to see that the converted new case Do you see that this case began May 15th, 1995?
Yes, sir.
Was a yes, sir. Next question.
Okay, I didn't hear. I'm sorry, I didn't hear. Okay, and did you see that it was filed out fees on the same date, supposed to be here, and it was actually transferred from Leon County? You see that as well, correct?
Yes, sir.
Okay. And you also see that there was an amended petition on February 9th, 1998, correct?
Yes, sir.
Would you agree that that more than 120 days passed between May 15th?
Objection calls for a legal conclusion.
No, it doesn't. It's a factual basis.
Hang on. Let him finish his question.
Thank you. Would you agree that between May 15th, 1995 and February 9th, 1998, more than 120 days passed?
The department renews its objection that calls for.
Sir, can you stipulate that more than 120 days transpired between the 3 years of these two documents being filed, Ms. McCarthy? Will you stipulate to that?
Yes, Your Honor.
Okay, I appreciate that.
Moving on. That's a fact in the record.
Okay, thank you. And would Mr. McCarthy also stipulate that between 1995 and 1998, there's no record activity of the department showing good cause for failing to serve?
The department would stipulate that this document shows no record activity between 1995 and 1998. That's correct.
Okay.
Including no dismissal.
Okay. And would you also stipulate to the fact that between 1995 and 1998, there's no record activity showing an attempt at service?
Run this document now.
Okay, thank you. That'll work. Okay, so would you also stipulate that according to the record on September 10th, 1998, an amended petition for support was filed?
Yes.
Okay. Will you also stipulate that between May 26th, 1999 and September 10th, 1998, there was no service of process?
To clarify, do you mean no attempt at service of process or no?
That wasn't my question.
Successful
No
service?
successful service of process.
There was no successful service of process. There were attempts at process.
Will you, I'll stipulate that there appears to be one. We don't have any proof of that, but there's an alias. Will we also stipulate that there is no record proof that there was ever a court hearing where the department asked for an extension of time to serve service of process?
There's nothing on the record about that. I can't stipulate to that. I was not working for the department or the Attorney General's office when all this occurred, so I don't have any personal knowledge as to what may have occurred otherwise at the time.
Will you stipulate that there was no evidentiary hearing to determine good cause for not serving from 1995 to February, from May 15, 1995 to May 26, 1999? Can we stipulate that there was never an evidentiary hearing to determine good cause for not serving process?
No, the department can't stipulate to that. I can stipulate that the record doesn't reflect any documents that would indicate that. But once again, I'm not aware of how the record was kept or how hearings were held back in the 1990s in this court. So it's possible that there were hearings that are not reflected on the court's record for one reason or another. So I can't stipulate that that definitely didn't happen. I can stipulate that the record doesn't reflect it.
Well, I'll stipulate I'll stipulate that the record doesn't show that it happened, and none ever took place as well. And by the way, you don't have to be working for the DOR or child support enforcement to just stipulate to the facts of the record, unless you're going to object to the record as being factually incorrect.
They've already stipulated to the record being admitted, so all of this is redundant.
But no, are you stipulating that the record is correct?
I'm stipulating that the record is the record that the clerk of court kept.
Okay, well, I guess Mr. Denton.
Once again, I was not practicing law when I was 10 years old, so I do not know what the practices of the clerk of court of Hillsborough County were at the time, as far as what was and was not reported on their record. So I cannot stipulate any further than that.
All that wasn't necessary. The question was, do you object? You didn't object to the record being presented, right? To the record at all, right?
The record has already been taken judicial notice of multiple times in this case, and there has been no objection from the Department of Revenue.
Okay. Now,
for the purposes the record can be taken judicial notice of.
Okay, so when you go to 6/7/1999, do you stipulate that the record shows that a summons was allegedly returned, on 6/1/1999?
Yes, individual service on you on May 27th of 1999.
Okay, and do you stipulate that on 7/19/1999 the clerk issued a default judgment on that based on the record?
Well, it's not a default judgment, but a default was entered against you for failure to follow responsibility. Yes.
Okay.
It's not a default judgment. It's just it's not a judgment.
But it's a default, right?
It is a default, yes.
Okay. All right. So I guess, Mr. Denton, what we have to do now is because is it now that Mrs. Britt can now go back to testifying?
I'm leaving in 6 minutes, and so we can either finish this within the next 6 minutes or another day.
I'll object to you minimizing my right to fundamental due process.
You're hearing the schedule. Yeah, you didn't ask for a specific amount of time, and when you filed your motion, you were given a full hour. If you need more time, you need to let me know now. How much longer?
I don't think that's the issue, but the issue is
I've been here for quite a few hours.
You took the job, Mr. Denton, and
Right.
pursuant to 876.
I'm leaving in 5 minutes now.
That's fine.
Finish this today, or you can, alternatively, you can take another day to finish the hearing.
We can do that as well. But first of all, you took an oath pursuant to 876 subsection 5 of the Florida statutes. And that oath was to support and defend the Constitution of Florida and the United States. And I could recite the whole thing down to 10, but you already know what happens when you don't do your job. So let's just go this. We'll go ahead and we'll continue this to a date that's convenient for everybody. But I want you to reconsider your recommendation.
Then file a motion.
Yes. I need you to reconsider that as well. And we'll come back and we'll
file a motion or do whatever you need to if the time still exists to do so.
Well,
it's entered March 21st. So
the court can always review its own order. Just make the recommendation to Judge Smith to reconsider his rubber stamping of your that foolish recommendation. Didn't make any sense. Didn't even apply.
Okay, well, your commentary is needless.
Well, so is yours. So is yours, but I listened to it, right?
What day do you want to do this, and how long do you need? Monday or Tuesday, morning or afternoon?
Let's do it Monday morning, so we can sit here all day. But you have to read.
I'm going to give you I'm going to give you a specific amount of time. You must request the amount of time that you need.
Is that policy, or are you doing that just to me, Mr. Denton?
Sir, I'm telling you that I
asked you a specific question.
How about this? How much time total do you need? So I can just
3 hours. And 3 hours. And by the way, can I get this? Because once I vacate your recommendation, I'm supposed to be heard by a judge by rule. So are we going to come back and hear both of them?
I don't understand the question.
Once I vacate your recommendation, I'm wondering why I keep coming back to you, because it's supposed to go forward to a judge. So are we coming back to reconsider the emergency motion only?
And you have to file your request, and then we'll make of it what we do. But you filed this motion before I even issued an order.
First of all, your recommendation. Thank you. I think it's part of the problem. Mr. Sabello, or Judge Sabello, is not properly training you people, man. It's like you have a policy pattern in practice of disregarding well-established law from its hearing officers. So just set it for the 8th at let's say 2 o'clock.
The 8th of what?
April.
Okay, well, I have about 10 hearings between 2 and 4
Well,
o'clock.
then don't ask me a question and then get upset with my answer. But like,
I told,
okay, I tell you what, you set the hearing, and if I have an objection, I'll file the objection. But let the record be real clear that
well,
that
and
the
tell me
PO,
before I allow 3 hours, what exactly we're going to be doing with those 3 hours?
I don't know, we're going to be sitting here trying to figure out, can you get me a witness who can testify to the DOR policies, and somebody who can testify to uh the procedure for making a determination if all the necessary prerequisites were met by the department when they filed this action, no matter when it was.
I don't supply witnesses. If you want one, you
No, I just asked you to have Miss McCarthy supply a witness. She keeps telling me what Mrs. Britt can't testify to. She's the one that brings her. I don't care who it is. You can bring Ashley Moody. I don't care. You can bring Ron DeSantis. I don't care. Bring somebody. No, I'm serious. He knows how I feel about him too. I just want you all to do your job. Because what I think has happened from all this is
Okay.
your malice has put me in a precariously dangerous situation if I come in contact with law enforcement. And I think you've done it maliciously. So I will report two of you to the bar, and I can say that because I'm not an attorney. And I'm also going to file the mandamus. But the reality is, I think there have been facts that have been outlined here in this hearing today, and I want the record to be clear, that show that the Department of Revenue cannot prove subject matter jurisdiction. And no matter what any judge and every judge in Hillsborough County, the 13th Judicial Circuit, has ruled on matters that do not address whether or not the court had subject matter jurisdiction and whether it was in the record. In fact, the court can't even produce the original complaint.
Okay. So you want 3 hours?
Yes.
Okay. I'll issue an order to continue, and I don't know if it'll be a Monday or Tuesday or some other day of the week. I'll think about it.
And well, you can think all you want to, but bring a witness that can testify to the truthfulness of the evidence.
Okay.
Bring all the evidence and all the prerequisites, by the way.
What was that?
Bring all evidence and prerequisites for filing an action. Just have it with you.
Okay. Have a nice day. Well, I'll issue an order.
A recommendation.